Good afternoon, Mr. Evans. Thank you for getting here.
Thank you, Judge.
I appreciate it, and I appreciate the magistrate for accommodating the court as well.
Share that with her next time I see her. She's very confident.
Mr. Harris is in the courtroom and we're ready to resume. With motions to suppress filed by the defense. First item is I have a Rule 22 from the Marietta Daily Journal. Any objection by the state?
No, Your Honor.
It does take the same position they have all along.
We do, Your Honor. Continue to put our objection on the record.
Objection is noted on the record. All right, I think the state had rested with its presentation of evidence, if I'm not mistaken.
You're correct.
The defense can proceed.
Your Honor, will not be introducing any evidence.
Thank you. I believe that we're at the posture where we're ready for argument. Would that be correct?
Yes, ma'am.
State has been approved.
We will waive opening just to start closing.
Mr. Lumpkin, when you're ready, you can proceed with your closing, please.
Thank you, Your Honor.
First of all, Your Honor, if I could, let me thank the court for the opportunity to have had some very, as I've heard it described, many different ways, painstaking, long-suffering, long motion hearings that we've had this week. And I know it is this area of law is somewhat burgeoning, it's still growing, and because of that, we need to put a lot of things on the record and make very clear. And I just want the court to know that I appreciate Your Honor's diligence and patience in allowing us to do that and the way we've been able to do so. I think it puts us in a very good position in order to address these very, very important issues, which of course are the Fourth Amendment protections that protect each and every one of us in this courtroom here today. I want to start, if I could, by looking back to wiser counsel than I in the Olmstead versus United States Supreme Court case from 1928, almost 100 years ago, when the court was dealing with the government's attempt to impose wiretaps on certain individuals in order to prosecute during the Prohibition years. Justice Brandeis, in his dissenting opinion in that case, wrote the following: "In the application of a constitution, our contemplation cannot be only of what has been, but what may be. The progress of science in furnishing the government with means of espionage is not likely to stop with wiretapping. Ways may someday be developed by which the government, without removing papers from secret drawers, can reproduce them in court, and by which it will be enabled to expose to a jury the most intimate occurrences of the home. That places the liberty of every man in the hands of every petty officer, as was said by James Otis, of a much lesser intrusions than these." And the question was asked, can it be that the Constitution affords no protection against such invasions of individual liberty and individual security? That was a very well thought out opinion and some foresight that Justice Brandeis had, because in fact the government has not stopped with its attempt to invade into the lives of its citizens. Under the initial inclination of effective prosecution and law enforcement, which we understand, there have been ways in which the government has found and pushed in order to get into the lives of individual people, into their homes, into their private affairs. And that's what this case brings forth to us, is a current day, cutting edge way in which the government has done exactly that. They have used the offices of the court, they have used the avenues at their disposal to misrepresent, mislead, misguide in order to obtain the private matters of Mr. Harris and others. And that greatly offends the constitutional protections that we're here today to defend. Justice Brandeis was right, because what we've seen in the nearly 100 years since is a new wave of investigation that looks into computers and cell phones. Most recently in 2014, the Supreme Court in fact upheld the ideas behind Justice Brandeis' opinion in the Riley versus California case. And in that case, they noted, among other things, that modern cell phones are not just another technological convenience. With all they contain and all they may reveal, they hold for many Americans the privacies of life. The fact that technology now allows an individual to carry such information in his hand does not make the information any less worthy of the protection for which the founders fought. Your Honor, we want to talk about these seizures and searches by the government in this case. And I'm just going to try to take them one at a time. We will be able to group some of them when we get to those groupings that make logical sense. I don't know of a better way to do it. I'm going to be as succinct as I can. But I want to be very clear that we are standing on every opportunity that the Fourth Amendment affords to protect the rights of not only Mr. Harris, but the citizens for years to come. Because as I said when we began, I believe this will be a historical decision this court will make. Regardless of what direction the court goes, I believe it will be looked upon in the future and reviewed and determined if in fact this court chose to protect individual liberties or to enable law enforcement to invade into the lives of its citizens. We start with the cell phone of Mr. Harris. Your Honor, our position is that the police improperly seized the cell phone of Mr. Justin Ross Harris on June 18th. He had just experienced the loss of a lifetime when he encountered and found his child deceased in the back seat of his car. As he was trying to deal with that situation and thinking about his wife and trying to get a hold of her to make sure she knew what was happening before she went to pick Cooper up from the daycare, in that worst moment of his life, the police entered and decided to start asking him questions. Yes, he was yelling, he was screaming, he was in a panic, he was hysterical, as the witnesses told us. And the officers interfered with his grieving process that had just begun just moments before. And in so doing, they tried to calm him down, which is perfectly fine. The officers had every right to try to calm him down, to try to speak with him. And in so doing, he issued a curse word that they didn't like. He issued it toward an officer who may be shorter than average, as they've testified to. But at the time that they took his phone from him, he had calmed down, he had gotten off the phone, he had put the phone in his pocket, and it was no longer in a position of any sort of upset to the point that they had to take the action that they did. What they said is, or at least what they said now, is that the phone was being attempted to be put in his pocket. And then when we cross-examined them about their prior testimony, where they said very clearly, we took it out of his pocket after he was handcuffed. Well, that means he had to have put it in his pocket. And then they said, well, it wasn't seated fully in his pocket. And we see a lot of this testimony from the law enforcement of taking certain words and trying to give special characterizations and special meanings to them. But the bottom line is, they're trying to say that he was obstructing them. But in fact, there's no charge of obstruction. There was no obstruction. He had done exactly what they'd asked him to do by putting the phone away, and they had already made the decision to encounter him and come at him and lay hands on him. Had that been all they had done, it would have been fine, but no, they went to the next step and actually seized his phone from him. Not under arrest, not a safety issue, not a problem of any sort. It was in his back pocket by their own testimony. Now, they've come in here this week and tried to suggest, well, maybe there was some sort of safety concern, but he was just a regular citizen dealing with grief. Then they say, well, they need to treat him as a suspect. Well, there was no reason to treat him as a suspect. He was a simple citizen trying to deal with his grief. Then they said, well, there's a transport issue. We don't transport defendants with phones. Understandable. He wasn't a defendant. He was a citizen dealing with his grief. There was no reason to take the phone, to withhold the phone, to prohibit his calls. They talked about, well, he might be able to get on the phone and text people and call people. Well, so what? That's what citizens are allowed to do in this country. He had not committed a crime. He was not under arrest by their testimony. They were trying to calm him down. He calmed down, and they took his phone away from him. It's an improper seizure that they took out. There's no crime for him to call somebody or text somebody about, again, this worst moment of his life. There was no warrant, there was no exigency, there's no probable cause. They simply took the phone away from him. Now, the question seems to be, was he in custody somehow that allowed them to take his phone or not? Well, fortunately for us, the court's already answered that question. In your prior rulings, you've said no, he was not in custody. So, their taking of his phone was a completely unlawful seizure without probable cause, without warrant. And to then suggest somewhere down the road that, well, it's okay if we got a search warrant later, well, that doesn't fit the constitutional protection that he has not to have the phone taken from him to begin with. Just because they felt like he was acting in a suspicious way, that's no basis for assuming there's criminal activity. His mere refusal to identify himself is not a crime. And even the use of cuss words toward an officer is not obstruction in and of itself. And Your Honor, I'm not going to be saying and providing all the citations. We'll be providing that in written form after this hearing in order to kind of move things along. Secondarily, Your Honor, after the phone was illegally seized, our position is that the police improperly searched that cell phone without a warrant. It's clear that they wanted to get into his phone. Detective Stoddard was asking for the password within hours of their seizing it. They got a search warrant within hours of their seizing it to search it. They gave it to High Tech Crimes in order to download the whole thing. But then, all of a sudden, the convenient testimony is, well, we didn't bother to look at it for 6 days. When asked about this by Detective Yeager, about what did you do when you downloaded the phone, what did you look for? He told us as clearly as possible that a detective gave him a specific name that he had never heard of before to look for on that phone. The only way that that information could have been known to law enforcement is for someone to have already searched that phone prior to that search warrant being obtained. There simply makes no sense any other way. Now, after we took a break and the detective left the stand and then came back, all of a sudden, well, I can't say for certain that's what it was. It's possible, but it may have been some other way. Your Honor, you get to judge the credibility of these witnesses, and you made the point yourself at one point during this week of, yeah, there are some credibility questions here. We're going to ask you to use common sense and look at what the officer said. Why in the world would this experienced officer say point blank, yeah, the reason I looked for that is because the detective gave me that information. I can't remember which one, but I know they did. And then after the fact, an attempt to maybe hide the fact that they've in fact searched that phone, he comes in and says, well, maybe I got another way. But notably, he cannot eliminate the fact that, well, maybe I did get it from a detective. If it had not happened that way, there'd be no question in his mind about that. He also mentioned the Reddit sites. Again, no reason whatsoever to be looking for that in the thousands of bits of information in that phone, except for what he originally told us, which was, yes, I was provided that information by a detective to look for that information. And we know when he did it, on June 20th. June 20th, less than 48 hours after this incident has occurred. And the state would have us believe that, well, no, we didn't look at that phone for 6 days. How long it takes to do a forensic search on a phone, just to do the downloading of it takes hours. The process of going through it, trying to find information. And the suggestion is, well, somehow, even though they just downloaded it on the 19th, that in the minimal amount of time, they downloaded it, searched it, found these items, put it into a report, put it on a disk, then got it to Detective Stoddard, just in time for him to magically be interviewing that very same person on the 20th. It's very clear why the state is trying to suggest that maybe they got it another way, because they know very clearly, the United States Supreme Court has told us, you can no longer search a phone incident to arrest. Riley versus California told us that last year. It's a change in the law, and maybe some of the officers aren't aware of it yet. Detective Murphy told a magistrate that in fact it was seized incident to arrest, which, as he indicated, are words of art. That's something they look at, they know what that means, that has a specific meaning to them, and in this case, it told somebody, we can go ahead and look through that phone if we want to. Unfortunately for them, the Constitution has protections against that. They've been enforced by our Supreme Court. Now, moving to the actual search warrants themselves. The court is mindful of the basic rules of law that apply in this situation. First and foremost, the United States Constitution, Fourth Amendment to the Constitution, as well as the Georgia Constitution, Section 1, Paragraph 13, states the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. We take for granted our constitutional rights, I think, a lot of times, but it's cases like these that bring them back to the fore, how important it is. Just as important as the right of the press to be here filming this going on here today, and there's been all sorts of issues dealing with that in the past, Mr. Harris's rights are still paramount. As the accused in this courtroom, his constitutional rights should be paramount. And for each of us, the securing of these rights is important because, but for the grace of God, could be any of us sitting in that chair where he sits today. Statutorily, OCGA 17-5-21 also sets out the process of obtaining a search warrant. And it says, upon the written complaint of any certified peace officer of the state or its political subdivisions, charged with the duty of enforcing the criminal laws and otherwise authorized, under oath or affirmation which states facts sufficient to show probable cause that a crime is being committed or has been committed, and which particularly describes the place or person or both to be searched and things to be seized. And those any instruments, articles, or things, including the private papers of any person which are designed, intended for use, or which have been used in the commission of the offense in connection with which the warrant is issued. And those three delineating factors of pieces of evidence they can actually seize is hugely important, especially in this case, because as we'll talk about as we go through this, the evidence they were looking for is not evidence that's designed, intended for use, or which had been used in the commission of the offense in connection with the warrants they were issuing. They had a theory, and they wanted to go hunt and fish and trawl and see whatever they could look into to try to find something to fit a theory that they had. The Fourth Amendment says that's improper. Our own Supreme Court reminds us that in order to have a search warrant issue, there should be sufficient facts that a crime has been committed, that the items sought are connected with the crime, and that the items sought will be found in the place to be searched. And of course, our United States Supreme Court has narrowed this definition to tell us that probable cause requires a magistrate to conclude there is a fair probability that contraband or evidence of a crime will be found in a particular place. Fair probability does not mean some small possibility, some hunch, some suspicion, some wish. It means there has to be a fair probability. There's got to be something upon which we can base a reasoned decision and conclude that yes, you can interfere to a citizen's life because you've got some investigation that tells me there's a fair probability there's evidence there to be found. Let's talk about the individual search warrants. First of all, the first search warrant, which is of the residence, which is 14 SW 0596. First of all, when we look at that affidavit, there's absolutely no probable cause that a crime's even been committed. When the court looks at that affidavit and looks at it specifically, the information is there is that Ross forgot his child in his car. It's stated twice in that affidavit. It's not rebutted. It's not supposed to be otherwise. It's not guessed at otherwise. There's absolutely nothing to indicate that that's anything other than the factual allegation that they have in that warrant. Even the oral testimony adds only that, well, he's not showing much emotion. Well, we've got a big question with that. How much is not much? We know that that particular witness actually spoke to eyewitnesses who described Mr. Harris as hysterical, in a panic, yelling and screaming, holding his hands on his head, talking on his phone in a loud voice. I don't know how much more emotion they would want someone to have, but when they decide they want to go into someone's personal property and personal residence, well, we'll just call it not much emotion. A warrant must stand on firmer ground than mere suspicion, which is basically all they had, was mere suspicion based on someone just felt like he wasn't showing enough emotion. There's multiple cases going as far back as the 60s that tell us very clearly that that's not the case. That's not allowable in the United States of America. Our own Georgia courts have told us in the Willoughby case also, the mere speculation, conjecture, opinion, or rumor is insufficient to show probable cause. The only evidence that the affidavit sets out in that search warrant is that Justin Ross Harris forgot his child. That's what he said. That's what happened. That is not a crime. There's absolutely no probable cause that a crime was even committed in that first affidavit. Secondly, there's no connection of even the purported crime that the state wants to believe is there to what they're wanting to look for. Their search warrant is for papers, writings, documents, and photos connected with child abuse and child neglect. What possible connection can there be of searching his house of what happened in the hours during the daytime of Cooper Harris being left in that car? There's absolutely none. Absolutely none. And if there were any attempt by the state to actually investigate, and even if they had just bothered to put in the affidavit some experience and training which would indicate why they think there's some evidence at the house, they didn't even bother to do that. Thirdly, there's no probable cause that evidence would even be found in those locations. The testimony made it clear they had no evidence at all. All they had was the interview with Mr. Harris and having talked with the witnesses who saw them on the scene. That's all that had been provided to the magistrate. There's no evidence of anything occurring around the house, in the house. Nothing at all about the house being involved whatsoever. And there's nothing about this death. In fact, they said themselves, yeah, what we thought was initially was it was just a failure to provide sustenance. Him being left in that car, in that parking lot at the Home Depot. The state, the law enforcement needs to be reminded there are basic rules they must follow to interfere with someone's life. We're not asking much just to simply state, what does your training and experience tell you might be a reason there's evidence in the home? The reason we don't have it in this case is because there was none. There was nothing they could provide to indicate that there would be any evidence of any photos, documents, writings, papers of child abuse and child neglect. And that's borne out by the fact when they go to the house, in fact, that's exactly what they found. Absolutely no evidence of any child abuse or child neglect. Interestingly, the Georgia Appeals Court, State versus Staley, aptly named maybe, 2001 case, 249 Georgia.
Or didn't it?
No relation that I'm aware of, Judge. But interestingly, though, the motion to suppress had been granted and the court affirmed it, where a search warrant of defendant's residence had been sought. And here's what's interesting. In that case, you had a convicted child molester. Someone with a record known child molester, multiple times, that was then observed by law enforcement, meeting with a small elementary school age young man, taking him to the mall, to an ice cream shop, secreting him around. And in the process of seeing that, they decided they were concerned because in his past history, they knew that in fact he had taken photographs and done things inside residences. But in this case, there was none of that. The court found that, in fact, there was no evidence of anything connected to that house. There was no evidence that there was any existing connection between what they were wanting to search and the actual information they had. At least in that case, they did an investigation. They had some background information. In our case, absolutely neither one of those is present. When you have a lack of probable cause, well, it nullifies any search therein. in this case, because of that initial warrant, which was so bare bones and without probable cause and connection, they went in, saw items in the house, and then they got a second search warrant to try to obtain electronic devices. Anything that they gained as a result of that first search warrant, Your Honor, we submit as fruit of the poisonous tree. You can't use an illegal search warrant, an illegal search and seizure, to then bootstrap a secondary search and seizure, which is what they did in this case. The second search warrant, 14 SW 0597. Now the change between the first and the second one is now we have a material misrepresentation. And the court's very familiar with it. We've talked about it quite a bit. You have this claim that Ross had researched child deaths on the internet. When we cross-examine and actually get to the heart of what was actually said, they said in the affidavit, he stated that he had recently researched this. Fact of the matter is, that is completely bogus. He never stated that. He never said anything close to that. He said he had watched the news report. He said he had seen a video on the internet about a vet talking about how hot it gets in a car. What should be even more concerning is what this court has to deal with is Detective Murphy, he considers himself a researcher because everything he sees and does, he considers research. So researcher Murphy decides to go to a magistrate and swear under oath what he heard some unknown detective, or unnamed detective anyway at this point, who was watching this interview secondhand giving information to Detective Murphy. I can't think of anything more reckless than a detective stating under oath to the magistrate in order to get into someone's home and into their private lives, into their computerized electronic devices, by simply saying, well, I'll try the submarine approach. What'd you hear him say? What'd you hear him say? Okay, I'll go with that. And we find out that, in fact, it's hugely important in this case, because that's the only thing in the second warrant affidavit that even comes close to raising some concerns about a crime taking place. As Franks versus Delaware tells us, a false statement included in the affidavit by the affiant knowingly and intentionally, or with reckless disregard for the truth, and that's necessary to the finding of probable cause, and the search warrant must be voided, and the fruits of the search excluded from the trial. At the very least, we've got reckless disregard for the truth. The Detective Murphy is simply stating things, if in fact that's how it happened, that's how he's testified, is that at best he heard somebody say this word and he went and swore to a magistrate. That's what Mr. Hare stated. Fact is, it's not true. Again, even with that little bit of information, there's still not any attempt to state any connection between this researching and the alleged crime. There's no attempt to confirm what piece of evidence they think this is going to provide for them. Even if they believe there was some researching there, how are we going to find evidence that's intended for use in, designed for use in, or has been used in, or is tangible evidence of a crime? Even in their own story, Your Honor, they make very clear they didn't have any idea what was on those computers. They just wanted to look through it. They just wanted to see what might be there. And in fact, is again borne out by the fact that they did not find one shred of evidence of any item intended for use, designed for use, or tangible evidence of the crime of homicide and first-degree child cruelty, which is what they had stated in that warrant they were looking for. For that reason, any searching of those electronic devices, the seizure of those, and the resulting search should be suppressed. Thirdly, we have the warrant of the vehicle, 14 SW 0598. Again, we have the same material misrepresentation about the research. We have no probable cause for the crime that's being alleged, again, because our affidavit is staying basically the same. There's no computer crime involved here. Now, certainly the looking into the car where the child has been found deceased, certainly looking for the car for biological information and the car seat and things of that nature, that makes sense. Finally, we've got a connection to our crime. Third warrant in. Sure, we want to look to see what evidence there might be in the vehicle itself. But specifically, they asked to look into electronic devices in the car. Now, interesting how they would even know they're there if they were in a bag somehow in the car and they have not already searched the car prior to getting the search warrant. But in any event, they have no testimony of anything happening inside that car, anything that involves any of these devices, that Cooper's death is somehow related to those devices, that somehow he was struck, hit, fell on, anything of that nature. Had they had something like that, then certainly there would be probable cause, but we don't have that in this case. And then when asked, well, what evidence are you going to find in these devices? I had no idea. No idea. If they had not looked at the cell phone at that point in time, then of course there's no evidence at all that anything would be on the computers to show any evidence of child cruelty or intentional homicide. And ultimately, Judge, this is the heart of our issue. The Fourth Amendment is being so disregarded by the law enforcement, at least in this case. My experience tells me we have it in other cases as well. But as far as the court's concerned in this case, these exploratory fishing expedition, trolling warrants that the law enforcement is taking out simply must come to an end. They've got it in their heads, but as long as we have a crime of a serious nature, let's just go get somebody's computer. If we get their computer, we're going to look and see what they're into. And if we look hard enough, we might find something that might stick against them. It might be evidence of a crime, or it might just be evidence of something we don't like about them. It might just be something we can use to taint them, to stain them, to get someone looking at something else other than the actual alleged crime. Riley versus California tells us very clearly that that shouldn't be happening. Arizona v. Gant in 2009, our U.S. Supreme Court also talked about that there's a concern about giving police officers unbridled discretion to rummage at will among a person's private effects. And that's what they're seeking. That's what these search warrants, they're being provided without check, without balance, oftentimes without question in this case. Simply must be stopped, and the Fourth Amendment protection imposed back upon our citizens to make sure that it does not continue. If the police are given this ability to search computers of anyone that they just find to be suspicious, without any evidence to support probable cause, that evidence will be found in a particular place, then the Fourth Amendment might as well be dissolved, because it means nothing anymore if in fact they're allowed to do that. Fourthly, the warrant for the iPhone 5S that was in Mr. Harris's possession at the time before it was seized illegally by law enforcement. Again, there's no probable cause for a crime in this warrant as well. There is additional oral testimony that was provided that claimed that this phone was seized incident to arrest. Again, interesting that Detective Murphy thought it was helpful to put that information in there. Interesting because they've come to court and very vehemently tried to, and have convinced the court that no, he wasn't really under arrest. We took him into custody, handcuffed him, put him in the back patrol car, let him sit there for a long time, and took him immediately to Cobb County Police Headquarters, but he was not in custody. Well, even if there was any reliance trying to be put upon that, Riley and Arizona v. Gant tell us they can't do that. This court's own ruling has already made it clear that they cannot rely upon that. Was there any probable cause of any evidence to be located on the phone? Well, when asked, researcher Murphy, when asked by the magistrate, admits, no, we just want to search it. We want to hope to find something about his day. That was his words to the magistrate. We're just going to hope. That's what fishing expeditions are all about, having a little bit of hope. Throwing your hook out there, see what you might find. Thirdly, there's absolutely no particularity specified in this warrant as to what they're looking for. What he wanted and what he told the magistrate is he just wanted to dump the cell phone and search for any evidence they could find. The law requires they particularly describe what is it you're looking for, what is the piece of evidence that you think you're going to find, what is there a fair probability to be located, and this warrant, there's not even an attempt to try to particularize what that would be. They simply ask to dump the phone. Maryland versus Garrison, 1987 U.S. Supreme Court case tells us, enlightens us on this point where it says the warrant clause of the Fourth Amendment categorically prohibits the issuance of any warrant except one particularly describing the place to be searched and the persons or things to be seized. The manifest purpose of this particularity requirement was to prevent general searches. By limiting the authorization to search to the specific areas and the things for which there is probable cause to search, the requirement ensures that the search will be carefully tailored to its justifications and will not take on the character of the wide-ranging exploratory searches the framers intended to prohibit. And frankly, over 200 years now have passed since our framers were concerned about these very things happening. When a oppressive government decided, if we want to come in your house and see what you've got, we'll just issue a writ to do it. Doesn't require any probable cause. And that's why the framers came together and decided, no. We're going to be independent. We are a self-governing people. We hold certain truths to be self-evident. Among them, the life, liberty, pursuit of happiness, and to be free from government searches of this nature. Next is a group of warrants, Your Honor, of 14 SW 0605 to 0611. This is a group of warrants seeking specifically searching of electronic devices. When we look at the affidavit, again, there's still no probable cause for any crime. There's been no addition. Here we are on the 19th, the next day, and there's been no investigation, no attempt to try to provide some information that'll help explain why we think there's evidence here. What it is we think we're going to find, other than a hope and a prayer. However, what they do add is a second material misrepresentation. Now, they add the information, well, Leanna Harris also stated that they were researching in-car deaths and how they occur. When we look at the actual evidence, the truth, when the defense pulls out the truth from this detective, what did she say? No, you see news reports about these things. It's a big fear. The word research never came out of her mouth. The concept of researching never came out of her mouth. The definition of research of being some intentional, diligent search for information did not occur. There was no evidence of it whatsoever. But Researcher Murphy gave that information to the magistrate in hopes of helping bolster what was clearly not sufficient probable cause to begin with. Then there was no probable cause of evidence to be located in a particular place. The Dell Dimension 9200 ends up, it doesn't even have a hard drive on it. It's just a box. Now, they'd already searched the house. They knew it was there. They knew what it was, or should have at least, if in fact they'd investigated it. But they had no probable cause to find anything there. When asked, Murphy says, well, I don't know what we'll get off of it. We just want to take all the information and dump it and look through it all. That's the essence of the problem here. That's exactly what they think they're allowed to do. That's exactly what the Fourth Amendment says they cannot do. Then, when asked questions about the intentionality of the crime, he gives completely inconsistent answers. Well, is it intentional? Well, no, we don't think so at this time. Less than 2 minutes later, so you think there was some deliberate action? Oh, yeah. He doesn't know what he's talking about. He's just trying to answer questions to satisfy the magistrate just so he can get that warrant. The state tried to rehabilitate him by saying, well, now you were just talking about your personal opinion. I mean, you may not officially have had information about intent, but you personally felt like there was. Well, that's not his job to give personal opinion. His job is to provide actual evidence, actual facts. What is it that the law enforcement has evidence of to support a search warrant? The Google Chromecast, I don't know how much more clear it can be. He didn't have a clue what it was. There was absolutely no probable cause that anything could be found on it because it's not even physically able to have anything on it. When asked what it was, he gave different definitions. Oh, well, yeah, it's a way of storage device. It's a way of keeping information. An outright lie. This court should be bothered by police officers outright lying to judges in order to get search warrants. At some point in time, someone's got to say, law enforcement, we want you to do your job. We want you to do it well, but we're not going to put up with you making up things. We're not going to accept a laziness that says, here's what we want, you just give it to us. The MacBook Pro, it was dumped on the 20th of June pursuant to these warrants. The iPhone that was found in the car, again, no evidence that Mr. Harris even used it. We know he was on the other phone. No evidence at all to connect anything being on this phone as evidence of the reason for Cooper Harris's death. The The requirement that warrants shall particularly describe the things to be seized makes general searches under them impossible and prevents the seizure of one thing under a warrant describing another. As to what is to be taken, nothing is left to the discretion of the officer executing the warrant. And we'll readdress this when we talk about the scope of the execution of the warrant. But clearly the directive in Marin versus United States in 1927, again, nearly 100 years ago, our Supreme Court is saying very clearly, you must have specific information in order to get probable cause. The warrants that were then taken on June 24th, 14 SW 0633 through 0639. Again, as far as the probable cause for the crime, there's still no probable cause for anything other than the fact of what they've alleged. When they bring facts to the magistrate, that's what the magistrate has to look at. The facts they brought is that Mr. Harris said, yes, I forgot my child. I left this morning and I went to work and I was supposed to take him to daycare and I forgot him. And he was distraught and he was upset. And there's absolutely no rebutting of that information anywhere in this written application or the oral testimony. Now, if in fact he were negligent even in leaving Cooper Harris in the car to a criminal level, not simple negligence, but even criminally negligent, and that still would not involve in any way the electronics in his house or the electronics in his car, based on the information they had at that point in time. Here's what they did add to that affidavit. Well, Mr. Harrison indicated some knowledge about a car seat. Wow. He knew about the car seat that his child was sitting in. They said that the straps were set on the lowest level. We don't have any source of that information. There's just a conclusory statement. No indication of who checked that out, who saw it, when they checked it, where that information came from, or any explanation as to why that even matters. There's statements about Cooper being normally developed. Again, no rebuttal of that. There's no evidence of any connection of that to a negligent homicide. The business venture. Well, the fact that Mr. Harris was going into business, working with some other people. Again, there's not even an attempt. It'd be one thing if they were attempted it badly, but they didn't even attempt to show that this business venture has anything to do with Cooper Harris' death. They talk about evidence of inappropriate sexual communications with other women. Well, that arguably might be something to look at, but unfortunately the basic rule that law enforcement again failed to do, what the Supreme Court of Georgia, United States, our own statutes make very clear, you've got to give the magistrate an actual source of your information. This is supposed to be a neutral, detached magistrate listening to what you're providing, not being a player on your team, not trying to read into what you're saying, not trying to pull out information, although frankly, me and the magistrates in this case, we're trying to assist Mr. Murphy and asking him questions. Of course, they'd ask questions and sometimes the answer was yes, sometimes the answer was no, sometimes the answer was, I don't know. But without any source of that information, with no evidence of when it was obtained, and most importantly, there's no evidence of when that was communicated, that it has anything to do with June 18th. They add that Leanna Harris said one of her worst fears was leaving the child in a hot vehicle. Well, again, not surprising. That's what they're dealing with right here, right now. So as they're interviewing her right here, right now, that she's an issue does not probable cause make. And then they talk about items secured through the prior warrant, these electronic devices. Well, as we've already said, those were invalid warrants to begin with. They've got even less information than these have and absolutely no probable cause of a crime or connecting to the items that were seized. Then the question is, well, what about probable cause that there's going to be evidence at these places we want to look for? And again, this is the second prong of the tremendous problem that we have before the court. When asked, Detective Murphy, what probable cause did you give that there would be any possibility or a fair probability or any possibility that there'd be evidence at this location? His response multiple times to me was to read the wish list that they gave to the magistrate. Well, I told him we wanted to look for this, and this. But that's not the question. what's the probable cause? What's the fair probability there's going to be anything there? I know that's what you want to look at. But the law requires you to actually give us some actual evidence, some actual indication, at least some actual experience that leads you to believe why there's a fair probability to be there. His response is, well, we tell him what we want to look for. Your Honor, nothing could be so further from the purpose of the Fourth Amendment of requiring there being probable cause of particular places to be searched, not just giving us your wish list of what you want to look at. If we trusted government, if our founders trusted the government, they would not have put that requirement in there to begin with. Sure, you just tell us what you want and you can go at it. Our law enforcement seems to have the wrong idea, believing that's all that it takes, is to just give them their wish list. And of course, this wish list is way overbroad in and of itself. Credit card debt, business information, life insurance, car seat searches, in-car deaths, at least those are related somehow to what we're dealing with. But then they ask for this: emails and communications regarding child, wife, and family issues. And that doesn't go far enough. They then ask for communications with other people on the days leading up to and including the incident date. These two phrases are the essence of the privacies of life that our Supreme Court was talking about nearly 100 years ago that need to be protected. None of these communications could be designed for, intended for, or actually used in the commission of the crimes alleged in these search warrants. This information was personal information to Mr. Harris, to Miss Harris, and in fact to the people that they communicated with. Court needs to be mindful these Fourth Amendment protections aren't just in place to be in these situations where you have a criminal allegation made. These are protections that protect all of us as citizens. So now not only is law enforcement invading the privacies of Mr. or Miss Harris's life, they're invading the privacies of whomever they had communications with for who knows how long. Finally, one of our magistrate judges stood up and decided to enforce the Fourth Amendment and told, you know, that's way too broad. We're going to take that out. Interestingly, Detective Murphy didn't even know it had been taken out of the search warrant until he was here on the stand the other day. So how in the world could the court have any assurance that the state was limiting itself to what was in the search warrant when the person who actually got it didn't even know that that had been removed? Of course, when asked about articulating some connection of the affidavit to the item sought, we get a great government answer. Well, don't ask, don't tell. He didn't ask me, so I didn't tell him. Show me in our Constitution and in the statutes and in the case law that tells me that's an exception to probable cause. As long as no one asks, you don't have to come up with it. Absolutely inappropriate. Absolutely unconstitutional. Search warrants on June 27th, 14 SW 0653 through 0660. This is for the thumb drives, flash drives, the DVD. Again, we got the same issues. There's no probable cause for a crime. There's improper information in the affidavit. There's issues of lack of connection of evidence. I won't rehash that. It's the same problem with these warrants as we had with the last batch. I am more concerned even though with the overbroad authorization in this case. Now, they're alleging second-degree child cruelty. No longer are they looking at intentional cruelty, but they're looking at criminally negligent cruelty. And so the lack of particularity borne out, the lack of any particularity of their warrants is borne out by the fact that absolutely nothing that they searched ever produced a single scintilla of evidence of child abuse or child neglect of Cooper Harris. Not one single bit. Then in warrant 0660, they take another warrant for the iPhone 5. Now, one question the court might have, why? Why are they taking another warrant for the iPhone 5? They've already gotten a search warrant for it. If, in fact, there was sufficient probable cause and there was sufficient information to allow them to search it, why in the world are they taking out another one? Well, it seems clear to me that they've already exceeded the scope of the first warrant. Because the first warrant, as bad as it was, still did not give them permission to be interfering and looking into whatever they wanted to in that phone for things that didn't have anything to do with that first-degree child cruelty or the homicide. And in fact, what they've been looking at is the personal affairs of Mr. Harris and trying to get in anything they can find that either they find suspicious or they just don't like. Has absolutely nothing to do with what was happening to Cooper Harris that day. And we'll talk a little bit about the scope of the execution in a moment. Then as to warrants taken on August 14th, 14 SW 0816 through 0844. Again, there's been no adding to these affidavits to make it any more clear. There's still no disproving, rebutting, anything to suggest otherwise other than what Mr. Harris said happened, that he forgot his child in his car. There's improper information in the affidavit again. There's lack of source information. There's false statements about what's been stated by Mr. Harris and Ms. Harris. And again, there's no connection of the evidence that's provided other than this being in the car. Other than there were some items in the car. There were some electronic devices, had absolutely nothing to do with child abuse or child neglect, had absolutely nothing to do with homicide, had absolutely nothing to do with intentional or criminally negligent child cruelty. Again, the authorization that's provided in that warrant, totally overbroad. Allow them to search through all sorts of communications of any sort without barrier, without anything to limit an officer to know what exactly am I supposed to be looking for. The authorization of these warrants basically said, you look through whatever you want to. The Constitution will not stand to allow that to happen. As to the computer that was in the car, the Home Depot computer, I think there's been some raising of the issue whether or not there'd be standing. Certainly, Mr. Harris had standing to contest the search of that computer. There's an expectation of privacy in his workspace, even when that's shared by others. Harper v. State, 283 Georgia 211, 1996 case, just one of many cases that makes that very clear. There's been no challenging or questioning. This was his car, his bag, this how they've related to it, how they've testified. It was his car, his work bag, his computer. So he certainly has an expectation of privacy in whatever was on there. Then as to the secondary computer, the prior computer that had been put in storage, again, he still has an expectation of privacy in what was on that computer that he put on there. Even though it may be in storage, it's still, because of his ability to use it, because of these cases that say in your workplace, you in fact do have an expectation of privacy. But what's interesting is, what could possibly be on there 3 months prior that has anything to do with what happened on June 18th? The crime that they're now alleging, homicide, child cruelty in the second degree. There's absolutely no probable cause, certainly nothing offered to the magistrate, nothing even logically that connects 3 months prior to what happened on June 18th. Here's what's interesting. By this point in time, we know from their testimony, they've already gone down this path of looking into information that has nothing to do with the child cruelty charge. They're looking for information of a salacious nature to try to see, well, maybe he was having inappropriate communications. Maybe that's something we can tie to him. Let's put that on him. Maybe that'll make him look worse, since we've got him charged with his awful crime already without probable cause. If, in fact, that's what they want to do, and clearly that's what they want to do because that's what they did. That's what the evidence is told. That's exactly what they went looking for. All they would have had to have done was to change that charge on that warrant. Change the charge to sexual exploitation charges, what they ultimately indicted Mr. Harris for. Just make it clear, that's what we're looking for. If that's what the magistrate is told, if that's what the information affidavit is supporting, then there may be probable cause to show or to particularize why we're looking in these particular devices. They never did that. Lastly, the 2015 warrants. There's certainly no probable cause for these warrants either. These are the ones taken by Detective Stoddard. There is some slightly different information from each one as far as where these items are coming from that they now want to search. But there's absolutely no information in this affidavit indicating why these items might have any piece of information related to this case. There's still no source of this inappropriate communications, which is certainly what we know they're looking for at that point in time. Still, absolutely, a year later, they're still not providing any context or source information to the magistrate as to where they get that information. The word researching is still in there. We've learned Detective Stoddard believes the same as Detective Murphy. Well, research means anything you look at. No one bothered to tell the magistrate that they had their own dictionary and wanted to use words the way they thought they should be used. I think it's pretty clear they're just trying to cover up on the backside what they failed to do on the front end correctly. The third search warrant in 2015, again, is for the iPhone 5. They don't even know and can't even articulate to us what they might find differently than what they've already found. Why in the world are you doing it? Well, we've got some new technology. Well, is it going to show you anything new? Well, we don't really know. We can't even tell you what we found now. We've had technical difficulties, and who knows what's there. Of real interest, and I think of huge legal importance, none of these search warrants actually gave them authority to do the searching they did. Your Honor can look at those warrants, and in the box where it's supposed to show what are the items and the things you're going to be allowed to search and what you're looking for, the box is blank. It's blank. They sought the search warrant. They spoke with the magistrate. The magistrate has authority to issue search warrants based on probable cause. Here, the document they have, which is what they're stuck with, doesn't even have any authorization to search anything. Search warrant certainly cannot stand. Now, the state has mentioned something about inevitable discovery. As indicated yesterday, it'll be a novel argument. I'm interested to see how they're going to do it. But what the court knows is when you hear that term, here comes the state trying to come in the back door around the Fourth Amendment. Some people think, well, we're just talking about loopholes and technicalities. No, we're talking about the United States Constitution. We're talking about protections. What the state is going to offer to you is some sort of loophole and technicality. Well, we would have gotten this information otherwise. But here's what's interesting. Even if they could show that, the only way it would be inevitable is if they ever actually got a search warrant where they provided that information to the magistrate. Was it inevitable that they would do that? Well, we know it wasn't, because the actual facts show us a year later, they're still not giving that information to the magistrate. They're still materially misrepresenting information. There's still no probable cause. So any attempt to use inevitable discovery to bootstrap around the constitutional violation, we'd ask the court to deny that opportunity. There may be some argument regarding, well, maybe he gave consent by giving his passcode to the phone. Well, maybe we didn't really need a warrant after all because he consented to us searching it. Well, when the state travels under the theory of consent, it's the burden, and it's a very high burden to show very clearly that in fact consent was fully, voluntarily, knowingly given. Simply asking for a passcode does not consent make. Cases are very clear when we talk about other similar issues. Even consent to look into one's truck is not consent to look into the items and containers therein. Certainly it's not a perfect analogy, but it's all the more clear that if I can give you consent to look inside my vehicle, but that doesn't give you consent to look into the containers in the vehicle, certainly my saying, here's the passcode to my phone, does not give you consent to go searching through the thousands of files and bits of information within that phone. Once we get past the lack of probable cause, the facial insufficiency, the overbroad nature, all the problems that are in the search warrants themselves, then we have the even, well, I don't know if it's greater, but it's certainly as equally a problem and maybe more obvious of a problem in how the state is going about executing these warrants. I'm going to talk about some specific cases because it's attempts by the courts to give us direction for years now. And law enforcement not only is not heeding that direction, not heeding that guidance, but going the opposite direction and saying, we're just going to tell you what we want and you give us a warrant. United States versus Walzer, 275 F. 2nd, 981. It's a 10th Circuit case, and it references an earlier case out of that same circuit, United States versus Carey, C-A-R-E-Y. And it says this: in United States v. Carey, this court recognized the particular Fourth Amendment issues surrounding the search and seizure of computer equipment. The underlying premise in Carey is that officers conducting searches and the magistrates issuing warrants for those searches cannot simply conduct a sweeping, comprehensive search of a computer's hard drive. Because computers can hold so much information, touching on many different areas of a person's life, there's a greater potential for the intermingling of documents and a consequent invasion of privacy when police execute a search for evidence on a computer. Thus, when officers come across relevant computer files intermingled with irrelevant computer files, they may seal or hold the computer pending approval by a magistrate of the conditions and limitations on a further search of the computer. Officers must be clear as to what it is they're seeking on the computer and conduct the search in a way that avoids searching files of types not identified in the warrant. Well, in these warrants, where there's no limitation on them whatsoever, certainly there's no limitations to make sure you're not looking in personal affairs of political organizations, religious affiliations, social connections, medical histories. In fact, we know in the searching of these computers, they found exactly that information. And in fact, some of it was the very files that were pulled out and brought to a detective's attention. Here's some contact lists. Here's some people that they're in a group with. And again, not just invading the privacy rights of Mr. Harris, but the rights of all these people that simply have had contact with the Harris family. That case is important, even though it's not out of our jurisdiction, because our state Supreme Court has relied upon it, and our Court of Appeals has relied upon it, in talking about this. In Henson v. State, 314 Georgia Appeal 152, 2012 case, we see this. Although in that case we find the officer's search of the computer was not impermissibly broad, we do take this opportunity, as we did in Hawkins v. State, with regard to cell phones, to remind law enforcement officers to exercise caution when searching the contents of personal computers. As rightly emphasized by the 10th Circuit in Walser, because computers can hold so much information touching on many different areas of a person's life, there's a greater potential for the intermingling of documents and a consequent invasion of privacy when police execute a search for evidence on a computer. Officers must be as specific as possible in a search warrant regarding what it is they are seeking on the computer, and conduct the accompanying search, as the officer did here, in a way that avoids searching files that are not reasonably likely to contain the kinds of data identified in the warrant. In the Walser case and in Henson, what you have is officers who are looking legitimately for specific information on a computer. They've had probable cause in a warrant. They've particularly identified certain things they're looking for on the computer. And in the process of looking for drug sale information, lo and behold, they come upon what appears to be child pornography. And instead of just continuing to look and say, oh wow, that's interesting, let's see what more we can find, like the officers did in this case, they stop immediately, go to the magistrate, tell the magistrate what they've actually investigated, what they're seeing, and asking for a warrant that looks for that particular information. Again, it would have been so easy for the officers in this case to do that if they felt they had a probable cause to support it. Go get a warrant that addresses that particular crime. But they did not. Hawkins v. State, 290, Georgia, 785. Ultimately, the overall opinion in Hawkins is overruled by Riley, because in Hawkins there was a belief that at that time you could still search a cell phone incident to arrest. But the warning against excessive searches is still noted. The majority opinion in the Court of Appeals gave appropriate guidance regarding the scope of a search of a cell phone incident to arrest. The search must be limited as much as is reasonably practical by the object of the search. That will usually mean that an officer may not conduct a fishing expedition and sift through all the data stored in the cell phone. That's exactly what they testified they did in this case. Thus, when the object of the search is to discover certain text messages, for instance, there's no need for the officer to sift through photos or audio files or internet browsing history data stored in the phone. What do we have in this case? Well, we hooked it up to a special machine just so we could do exactly that. We want to get to the internet history, the browsing history, the cookies, everything we could find on that computer. We want to get as much of it as we can so we can just start looking through it. Shirley v. State, Georgia Supreme Court case from earlier this year, decided September 14th. Interestingly, the motion to suppress due to lack of probable cause in the affidavit had been denied. The Supreme Court reverses that. Tells us in that case you had an affidavit where it was claimed that German law enforcement authorities had an investigation into a website with child pornography that identified IP addresses, including Shirley's, that had access to 150 image files. And when contacted about it, Shirley invoked his right to an attorney. Well, that seems like, well, that might be probable cause. Somebody actually did an investigation and has specific information on what they found, and it was produced to the magistrate. But the point that we're making here is all the more clear in Shirley. The court made clear there was no acknowledging of the source of information specifically, other than just claiming, well, the German authorities have found it. It would have been easy. Well, tell us who those German authorities are. Who's the source of that information? When did they find it? Where did they find it? How did they find it? Just as that's missing in this case, it was missing there. There were no details as to what the FBI task force had done to investigate. Probably much like in this case, because there was no investigation. They simply got, somebody said something, and well, let's take that and run to the magistrate and get a warrant, just as Detective Murphy did in this case. Also, the court notably held the failure to provide some investigation into what the German information was to verify even what the word child pornography meant. Something that it would seem, well, we all know what that means, but the court said, no. When you're interfering and getting into someone's computer, we need to know exactly what the words mean, what you found, what the investigation shows. Contrary in our case, they're making up meanings for words. They're misstating what little investigation there's been. They're claiming information without any source whatsoever. And how do we know that they exceeded the scope? Well, it's in the fact that what they told us they looked for. What did you go looking for? Well, we first went to the contact information. We want to get all their contact information and their social connections. I asked, well, what else did you look at? Well, we looked at a whole bunch of stuff. I can't tell you. I can show you what I pulled off. And half of those are specific personal privacy interest protected material. Who knows what else they looked at? When asked, Detective Yeager, well, could you think of anything that you might look for that would be relevant? No, I can't even think of what that might be. Again, law enforcement's mindset is, if we want to look at it, just give us a warrant, let us go look. We'll see what we can find. We'll be the ones to decide whether it's relevant or not. We'll be the ones to decide whether you find out what it is or not. The Fourth Amendment says no. You cannot allow an unfettered, unlimited officer to use his own discretion to determine what he might look for. Not especially in these electronic devices. As we close, we had the question that Justice Brandeis had raised in Olmstead. Can it be that the Constitution affords no protection against such invasions of individual security? Well, we have an answer to that question in Boyd v. United States, 116 U.S. 616. A case that will be remembered as long as civil liberty lives in the United States. This court there reviewed the history that lay behind the Fourth and Fifth Amendments, and it was said with reference to Lord Camden's judgment in a prior case, said the following: the principles laid down in this opinion affect the very essence of constitutional liberty and security. They reach farther than the concrete form of the case there before the court with its adventitious circumstances. They apply to all invasions on the part of the government of the sanctities of a man's home and the privacies of life. It is not the breaking of his doors and the rummaging of his drawers that constitutes the essence of the offense, but it is the invasion of his indefeasible right of personal security, personal liberty, and private property, where that right has never been forfeited by his conviction of some public offense. It is the invasion of his sacred right which underlies and constitutes the essence of Lord Camden's judgment. Breaking into a house and opening boxes and drawers are circumstances of aggravation, but any forcible and compulsory extortion of a man's own testimony or of his private papers to be used as evidence of a crime or to forfeit his goods is within the condemnation of that judgment. Very fancy language, very flowery language to say this. Our founding fathers decided we are sick and tired of government telling us what they want, how they want to get into our lives without sufficient basis and probable cause, and we're not going to stand for it anymore. And when we create our new country, we're going to have the Fourth Amendment, among other protections, in place to say no. No person shall be subject to seizure without a warrant, to searches, unreasonable searches without warrant, without probable cause. Justice Brandeis' dissent in Olmstead ultimately proved to be true. When Katz v. United States came down, it overruled Olmstead in saying that, the government can't just search things that they want to search. They can't listen in on private conversations. They can't use technology they might have just to try to get at whatever they want without an actual showing of probable cause that a crime has been committed, connection of that probable cause to other pieces of evidence, and particularity that those items will have a fair probability of producing certain pieces of evidence. The dissenting opinion in Henson, that Justice Phipps penned, also proved to be on the right side of history, as Riley versus California came along and overruled that case here in Georgia. Your Honor, you stand at the precipice of history, frankly, in order to make a decision. Are you going to uphold personal freedom, personal liberties, constitutional protections against law enforcement's desire, and that's what it is, a desire to simply interfere in the lives of its citizens without probable cause? We're not asking you to say they can't investigate. If only they had done some investigation in this case, they might have seen what is in fact true. June 18th, 2014 was the worst day in Justin Ross Harris's life. He lost his precious child. That's something he'll have to live with the rest of his life. But it does not, no matter how tragic that is, that does not give the government the right to interfere and come into his life and try to find anything and everything about his life in hopes of finding something that they can say is wrong, is ugly, is something in their opinion suspicious. Investigate what happened to Cooper. Investigate how this happens every year. Dozens of times every year, parents forgetting their children in cars, many of which are not reported, many of which children don't die, thank goodness. Unfortunately, dozens of which every year they do. It's not a crime to accidentally forget your child. The evidence that they had when they started seeking these search warrants was exactly that. What Ross Harris told them in his grief, in his despair, in his horrible agony, the worst day of his life. And because he was simply trying to make sure his wife didn't show up at that daycare before someone knew what was going on, he said a curse word, officer got upset, and they took him into detention, and from that point forward sealed the fate that they started viewing him as they have, as they've testified on this witness stand. He was an arrestee, he was a defendant, he was a suspect. Fact is, Your Honor, he's a citizen. As a citizen of the United States, his Fourth Amendment protections should have been protected. They were not. We're simply asking the court to look into the actual evidence in this case, the facts, the testimony, the common sense here. Don't read into these applications and warrants things that do not exist. Don't allow the state to simply say, well, everybody kind of knew what they meant. We've got our own lexicon and we know what these words really mean. The fact is they did not produce probable cause. The reason we're here before the court today is to stand in the gap to uphold the constitutional right. The Fourth Amendment protects each and every one of us, each and every one of us in this court. We ask that court to uphold that protection and grant each and every one of our motions to suppress as each of these warrants. Thank you.
I think we'll take a brief, let's take 10 minutes. Mr. Martin, thanks for your argument.
Anymore. I think I'm going to turn it